Professional and ethical duty of a chartered accountant. Professional ethics of a chartered accountant are governed by Code of Ethics, the Chartered Accountant Act 1949, Council Guidelines, recommendatory self-regulatory measures. In Chartered Accountant Act 1949, it contains details about membership of the institute, either in case of chartered accountant in practice and chartered accountant in service, and type of misconduct, whether professional misconduct, other misconduct, disciplinary procedures, and schedules to the act. There are two types of schedules: Schedule 1, Schedule 2. What do you mean by professional misconduct or other misconduct for a chartered accountant? Professional misconduct has been defined in Part 1, Part 2, and Part 3 of the first schedule, and Part 1 and Part 2 of the second schedule. A member who is engaged in profession of accountancy, whether in practice or not, should conduct or restrict his actions in accordance with the provisions contained in respect of a part of the schedules. If he is found guilty of any of the acts or omissions stated in any of the respective parts of the schedule, he or she shall be deemed to be guilty of professional misconduct. Other misconduct. Other misconduct has been defined in Part 4 of the first schedule and Part 3 of the second schedule. These provisions empowers counsel to inquire into any misconduct of a member if it does not arise out of his professional work. So there are two schedules: first schedule, second schedule. First schedule contains 4 parts, second schedule contains 3 parts. First schedule 4 parts. First part, professional misconduct in relation to chartered accountant in practice. It contains 12 clauses. Part number 2, professional misconduct in relation to members of the institute in service. It contains 2 clauses. Part number 3, professional misconduct in relation to members of the institute generally. It contains 3 clauses. Part number 4, other misconduct in relation to members of the institute generally. It contains 2 clauses. Second schedule contains 3 parts. Part number 1, part number 2, part number 3. Part number 1, professional misconduct in relation to chartered accountant in practice. It contains 10 clauses. Part number 2, professional misconduct in relation to members of the institute generally. It contains 4 clauses. Part number 3, other misconduct in relation to members of the institute generally. It contains 1 clause. Second schedule to the CA Act 1949. Part number 1, professional misconduct in relation to chartered accountant in practice. It contains 10 clauses. Clause number 1, a CA in practice shall be guilty of professional misconduct if he discloses information acquired in the course of his professional engagement to any person other than his client, so engaging him without the consent of his client or otherwise than as required by law for the time being in force. Clause number 2, a chartered accountant in practice shall be guilty of professional misconduct if he certifies or submits in his name or in the name of his firm a report of an examination of financial statements, unless the examination of such financial statements and the related records has been made by him or by a partner or an employee in his firm or by another CA in practice. Clause number 3, a CA in practice shall be guilty of professional misconduct if he permits his name or name of his firm to be used in connection with an estimate of earnings contingent upon future transactions in manner which may lead to the belief that he vouches for the accuracy of the forecast. Clause number 4, a CA in practice shall be guilty of professional misconduct if he expresses his opinion on financial statements of a business or enterprise in which he, his firm, or a partner in his firm has a substantial interest. Clause number 5, a CA in practice shall be deemed to be guilty of professional misconduct if he fails to disclose a material fact known to him which is not disclosed in a financial statement, but disclosure of which is necessary in making such financial statements, where he is concerned with that financial statement in a professional capacity. Clause number 6, a CA in practice shall be guilty of professional misconduct if he fails to report a material misstatement known to him to appear in a financial statement with which he is concerned in a professional capacity. Clause number 7, a CA in practice shall be guilty of professional misconduct if he does not exercise due diligence or is grossly negligent in the conduct of his professional duties. Clause number 8. A CA in practice shall be guilty of professional misconduct if he fails to obtain sufficient information which is necessary for expression of an opinion, or its exceptions are sufficiently material to negate the expression of an opinion. Clause number 9. A CA in practice shall be guilty of professional misconduct if he fails to invite attention to a material departure from the generally accepted process of audit applicable to the circumstances. Clause number 10. A CA in practice shall be guilty of professional misconduct if he fails to keep monies of his clients other than fees or remuneration or money meant to be expended in a separate bank account, or to use such monies for the purposes for which they are intended within a reasonable time. Second schedule part 2 is applicable to professional misconduct in relation to members of the institute generally. It contains 4 clauses. Clause number 1. A CA in general shall be guilty of professional misconduct if he contravenes any of the provisions of this act or the regulations made thereunder or any guidelines issued by the council. Next, clause number 2. A CA in general shall be guilty of professional misconduct if, being an employee of a company, firm, or person, discloses confidential information acquired in the course of his employment, except as and when required by any law for the time being in force, or except as permitted by the employer. Clause number 3. A CA in general shall be guilty of professional misconduct if he includes in any information, statement, written or form to be submitted to the council, institute, or any of its committees, disciplinary director, board of discipline, disciplinary committee, quality control board, or appellate authority, any particulars knowing them to be false. Clause number 4. A CA in general shall be guilty of professional misconduct if he expresses his opinion on financial statements of any business or enterprise in which he, his firm, or any of his partner in the firm has a substantial interest. Next, part 3, schedule 2, part 3. Schedule 2, part 3, other misconduct in relation to members of the institute generally. There is only one clause. A member of the institute, whether in practice or not, shall be deemed to be guilty of other misconduct if he is held guilty by any civil or criminal court for an offense which is punishable with imprisonment for a term exceeding 6 months. So, a CA in general, that means either CA in practice or CA in service, shall be guilty if he has been imprisoned for more than 6 months, as per Schedule 2, Part 3, Clause number 1. Next, Council Guidelines. Council Guidelines states that a member of the institute who is an employee shall exercise due diligence and shall not be grossly negligent in conduct of his duties. The following part of the Code of Ethics shall be dealt with financial reporting. There are 2 parts. Part number 1, complying with code, fundamental principles, and conceptual framework. It is applicable to all CAs. Part number 2, it is applicable to chartered accountants in service. First one, part number 1, complying with code, fundamental principles, and conceptual framework. Another first one, fundamental principles. There are 5 fundamental principles. Hint is OCBI. O, objectivity. C, professional competence, confidentiality. B, professional behavior. I, integrity. Integrity means to be straightforward and honest in professional and business relationships. A chartered accountant shall not knowingly be associated with the information where he believes it contains a materially false or misleading statement, or contains statements or information provided negligently, or omits required information. Second fundamental principle is objectivity. A CA should not compromise professional or business judgments because of bias, conflict of interest, or undue influence of others. Next, professional competence and due care. That means attain and maintain professional knowledge and skill to ensure that a client or employing organization receives competent professional service, and should act diligently and in accordance with the applicable standards. Diligence encompasses responsibility to act in accordance with the requirements of an assignment carefully, thoroughly, and on a timely basis. Maintaining professional competence requires a continuing awareness and an understanding of relevant technical, professional, and business developments. Take reasonable steps to ensure those working in a professional capacity in his authority have appropriate training and supervision. Fourth, fourth fundamental principle is confidentiality. Confidentiality. A CA should respect confidentiality of information acquired as a result of professional and business relationships. A chartered accountant shall be alert to possibility of inadvertent disclosure in social environment, close business associates, or close family members. Maintain confidentiality of information within firm or employing organization, including prospective client. A CA should not disclose confidential information acquired as a result of professional and employment relationships outside the firm or employing organization unless there is a legal or a professional duty or right to disclose. For personal advantage or for advantage of third party, he should not disclose the information. After that relationship has ended also, he should not disclose the information. Circumstances where CSR or might be required to disclose confidential information or when such disclosure might be appropriate. If disclosure is required by law, if disclosure is permitted by law and is authorized by client or employing organization, and there is a professional duty or right to disclose when not prohibited by law, to comply with the requirements of peer review or quality review of the institute, to respond to an inquiry or investigation by a professional or a regulatory body, to protect the professional interest of the CAs in legal proceedings, or to comply with technical and professional standards, including ethical requirements. In such a case, he can disclose. Next, fifth fundamental principle is professional behavior. Professional behavior means a CA should avoid any conduct that chartered accountant knows might discredit the profession. A CA should be honest and truthful and shall not make exaggerated claims for the services offered, qualifications, or experience, or disparaging references, that means derogatory references or comparisons to work of others. A CA might face a situation in which complying with one fundamental principle conflicts with others. Then he should consult with others within the firm or employing organization or those charged with the governance or ICAI or legal counsel. However, such consultation does not relieve CA from responsibility to exercise professional judgment to resolve conflict or, if necessary, and unless prohibited, disassociate from matter creating conflict. Next, conceptual framework. A CA shall apply conceptual framework to identify threats to compliance with fundamental principles, evaluate threats identified, and address threats by eliminating or reducing them to an acceptable level. When applying the conceptual framework, the CA shall exercise professional judgment, use reasonable and informed third-party test. That means it is consideration whether the same conclusions would likely to be reached by another party. This is a reasonable and informed third-party test. Next, part 2, applicable to CA in service. Another first one, conflict of interest. A chartered accountant in service shall not allow a conflict of interest to compromise professional or business judgment. Conflict identification. First, in case of conflict of interest, there are certain steps. Under that first step is conflict identification. Take reasonable steps to identify circumstances that might create a conflict of interest and threat to compliance with fundamental principles. Such steps shall include identifying nature of relevant interests and relationships between parties involved and activity and its implications for relevant parties. Second step, threats created by conflict of interest. An action that might eliminate threats is withdrawing from decision-making process. Step number 3, disclosure and consent. Disclose nature of conflict and how threats were addressed to relevant parties and obtain consent from relevant parties to undertake professional activity when safeguards are applied to address threats. Next, preparation and presentation of information. Prepare or present information in accordance with relevant reporting requirements, access professional judgment to represent the facts accurately and completely in all material aspects, describe clearly the true nature of business transactions, and classify and record information in a timely and proper manner, and should not omit anything with the intention of rendering the information misleading. So, a CN service should follow all this in preparation and presentation of an information. He can use his discretion in preparing or presenting information. Do not exercise discretion with intention of misleading others. Example, determining estimates, accounting policies, timing of transactions, structuring transactions, etc. To misrepresent P&L, relying on work of others. A CN service should access professional judgment and consider the following factors in determining whether reliance on others is reasonable: reputation, expertise, and resources available to other individual or organization, whether other individual is subject to applicable professional and ethical standards. Third one, addressing information that is or might be misleading. If a CN service knows or has reason to believe that information is misleading, then take appropriate actions to seek to resolve the matter. Actions include discussing with superior, those charged with the governance, and requesting such individuals to take appropriate action to resolve the matter. Such action might include having the information corrected if the information has already been disclosed to the intended users, informing them the correct information, consulting policies and procedures of employing organization. For example, an ethics or whistleblowing policy regarding how to address such matters internally if information is still misleading. In case if the information is still misleading, consult with the institute, internal or external auditor, legal counsel, determining whether any requirements exist to communicate to third parties, including users of information, regulatory and oversight authorities. If appropriate action has not been taken and information is still misleading, he shall refuse to remain associated with the information and it might be appropriate to resign. Next, acting with sufficient expertise. A CN service should act with sufficient expertise. He shall not intentionally mislead as to level of expertise or experience possessed. A self-interest threat to compliance with principles of professional competence and due care might be created if a CA has insufficient time for performing or completing the relevant duties, incomplete, restricted, or otherwise inadequate information for performing the duties, insufficient experience, training, and or education, inadequate resources for the performance of the duties. Examples of actions that might be safeguarded to address such as self-interest threat includes obtaining assistance or training from someone with the necessary expertise, ensuring that there is adequate time available for performing the relevant duties. If a threat to compliance with principle of professional competence and due care cannot be addressed, he shall determine whether to decline to perform the duties. If he determines then declining is appropriate, he shall communicate the reasons. Next, financial interest, compensation, and incentives are linked to financial reporting and decision making. A CA shall not manipulate information or use confidential information for personal gain or for the financial gain of others. Inducements, including gifts and hospitality. An inducement is an object, situation, or an action that is used as a means to influence another individual's behavior, but not necessarily with an intent to improperly influence the individual's behavior. An inducement can take many different forms. For example, gifts, hospitality, entertainment, employment, or other commercial opportunities, etc. In case of immediate or close family members, inducement remain alert to potential threats created by offering of an inducement by an immediate or close family member of the CA to a counterparty with whom the CA has a professional relationship, or to an immediate or close family member of the CA by a counterparty with whom the CA has a professional relationship. If, if inducement is being offered and CA concludes that there is intent to influence behavior, He shall advise immediate or close family member not to offer or accept the engagement. Responding to non-compliance with the laws and regulations in case of employment with listed entities. When responding to non-compliance or suspected non-compliance, objectives of CSR to comply with principles of integrity and professional behavior by alerting management, those charged with the governance, by enabling them to rectify or mitigate consequences of identified or suspected non-compliance or deter the non-compliance where it has not yet occurred and take further action in public interest. Responsibilities of all chartered accountants. If protocols and procedures exist, address non-compliance, consider them in determining how to respond to such non-compliance. Responsibilities of senior chartered accountants in service. Senior chartered accountants means directors, officers, or senior employees. In case of non-compliance, first addressing the matter. Discuss with immediate superior, if any. If immediate superior appears to be involved in such non-compliance, discuss with the next higher level of authority. Determine whether disclosure to external auditor is needed to enable him to perform the audit. Next, determine whether further action is needed. Further action includes informing management of the parent entity, if any, disclosing the matter to an appropriate authority as specified under respective law, and resigning. Next, seeking advice. That means consulting internally, obtaining legal advice, consulting on a confidential basis with the institute, determining whether to disclose the matter to an appropriate authority. It would be precluded if doing so would be contrary to the law or regulation. Otherwise, the purpose of making disclosure is to enable an appropriate authority to investigate and take action in public interest. What are the responsibilities of chartered accountants other than senior chartered accountants? If CA identifies that non-compliance has occurred or might occur, he shall inform an immediate superior. If immediate superior appears to be involved, he shall inform next higher level of authority. If CA determines that disclosure of matter to an appropriate authority is an appropriate course of action, the disclosure is permitted. So that disclosure can be made. Pressure to breach the fundamental principles. A CA shall not allow pressure from others to result in a breach of compliance with fundamental principles or place pressure on others that would result in other individuals breaching fundamental principles. Discussing circumstances creating the pressure and consulting with others might assist to evaluate the level of threat. Such discussion and consultation includes discussing with individual who is exerting pressure to seek to resolve it, discussing with superior, escalating to higher level of management, internal or external auditors, those charged with the governance, disclosing in line with policies, including ethics and whistleblowing policies, consulting with a colleague, superior, human resources personnel, another CA, institute, industry associations, legal counsel. An action that might eliminate threats created by pressure is request for a restructure or segregation of certain responsibilities and duties so that accountant is no longer involved with individual or entity exerting pressure